Hi, are you someone who's thinking of launching your own product line or new brand? Are you an existing business who wants to rebrand to increase your reach? Or are you simply someone who is fascinated by trademark and intellectual property law? If the answer is yes, then this episode is for you. Even if the answer is no, it wouldn't hurt for you to watch this episode. So, in today's episode of the Utsav Mukherjee Intellectual Property and Technology Law Show, I'm going to tell you about the basics of trademark law and how to protect a trademark under the laws in India. So before I get to all that, let me first tell you what a trademark is. In very simple words, a trademark is a mark which is capable of distinguishing the goods or services of one entity from that of another. It is the mark used to identify a brand. So it may consist of a certain shape, packaging, or combination of colors, or simply a name. In fact, there are two kinds of trademarks: word marks and label marks. Word marks mean the words that you identify with a particular brand, and label marks mean the labels that you identify with a particular brand. So think of all the famous marks that you look for when you go shopping on shoes, clothes, accessories, right? Or those famous names which are hallmarks of quality, goodwill, and reputation, such as McDonald's, Coca Cola, Pepsi, Quality Walls, Nike. And these are all trademarks. You immediately see or hear their names and identify them with one brand that they present. You would likely notice them more or choose their products over the products of unknown brands or lesser known brands. Now, as the founder of a new business, whether you are in a goods or services business, you would definitely think about a trademark to sell your goods or enter your services under. And this becomes even more relevant in today's brand driven world where a lot of business is happening online and consumers rely even more on brand value to make purchases. So now that you have decided on a certain trademark, how do you prevent other businesses from copying it or selling their products under it? For one, it would make sense to register your mark with the trademarks registry. Once your mark is registered, if anyone uses it, you can file a case before the courts for infringement of the trademark. Infringement here means violation. So, an infringer would be a person who has violated your legal statutory rights in your registered trademark. The court then examines your case, and if it finds that on the face of it, it is likely that consumers will confuse the other person's mark to be the same as yours or associate their products with your brand, it would grant an injunction, which is a temporary relief in your favor, restraining them from violating your trademark till the case is finally decided. Now, the final judgment would be given only after all the stages of the trial and evidence are concluded. Let me also tell you, you can file a case for somebody else using your long standing trademark even if your mark is not registered. However, this would be a case of passing off, which is a common law remedy and not a case of infringement or violation of trademark. Passing off means that the getup or appearance of the packaging or mark used is such that a person of average intelligence would confuse it to be the same as another. This includes not only visually similar marks but also phonetically similar marks, meaning that they sound similar. So, to make it simpler, let me give an example to you. If your mark is Reebok and somebody else uses a mark called Chibok, it would be a case of passing off, as they look and sound similar. If your mark Reebok is registered and somebody else uses the mark Chibok, it would not only be a case of passing off, it would also be a case of infringement or violation of the legal rights in a registered trademark. So, where both your mark and the other person's trademark are registered and a case of infringement or violation of the trademark is filed by you against them, the court will see whose mark has been used first rather than whose mark was registered first. This is because prior use is always given precedence over prior registration under the trademark law in India. So, those are some of the basics of trademark law in India. I look forward to bringing you more informative episodes on intellectual property and technology law in India in the exciting new technology driven massive economy that we are in. Cheers.